YouTube, everything's working? I think so.
By the way,
right. Oh, okay. Now I saw
Ariel, by the way, you influence a great amount of people with your paper.
Well, thank you. That's very kind.
Okay, everyone, let's start. I saw Lucas said it's working already. Okay, I can hear myself there on YouTube. So good afternoon and welcome, everyone. It's a pleasure to be here among so many bright scholars. My name is Vanessa Arns. I'm a professor of economic law here in Curitiba, and I will mediate our webinar today about competition law and digital markets. So I am here with Professor Ariel Ezrachi, as Lauder and May Professor of Competition Law, Oxford University, with Professor Juliano Maranhão, Professor of Law at University of São Paulo and member of the International Association for Artificial Intelligence and Law. Also with Professor Eduardo Molangaba, who is here, who is also a professor of economic law and leader of competition law at the Innovation Research Group at PUC São Paulo. Professor Vinicius Klein, who is also professor of law and economics at Federal University of Paraná and founding member of our ADEPAR, which is the Law and Economics Association here at Paraná, and also a Paraná State Solicitor. Unfortunately, we will not have the presence of Professor Juliana Oliveira Domingues, who is our professor of economic law at USP. She will not be able to join us today. And since I'm also the academic director of ADEPAR, I would like to thank Eduardo Tesserolli, our president, for organizing this amazing webinar. I'm sure we'll have a wonderful discussion today. I would like to thank the Federal University of Paraná and the University of São Paulo, who are helping to organize this event. I usually tell my students that competition law is the heart and soul of economic law. So our webinar today about digital markets, it's even more essential during this coronavirus pandemic, in which we are all living online lives. I was just in a birthday party online also 2 days ago, and I have studied the network effects in competition law there at Stanford University. So I'm sure it will be nice to talk about this matter today. I would like to thank you all for joining us. We'll be gladly accepting questions, and I would like to invite Adam Patterson to introduce our discussion today. Mr. Adam Patterson is the Honorary British Counsel for the State of Paraná and Honorary Vice President of BRITCHAM here at Paraná as well, and member of the Paraná Institute of International Relations. So you are all welcome to join our discussion. And Adam, Mr. Adam, let's hear from you. Thank you very much.
Thank you very much, Vanessa. Good afternoon, ladies and gentlemen. Bom dia a todos. It's a huge pleasure to be here with you all today to open up this fantastic webinar on competition law and digital markets. First things first, I would like to thank the support and partnership of Vinicius, Eduardo, and Vanessa from ADEPAR, the Paraná Economic Law Association, in making today's event possible. This is the second event we've done together, right, since quarantine started. We've started to adapt to this new normal of virtual events. The first was on Brexit, which generated a lively and insightful debate. And as I always say in these webinars, just because we have been practicing social distancing does not mean that we need to be distant from each other and distant from key debates and themes going on in the marketplace. Actually, and obviously the opposite is true, right? The world is increasingly connected and global, and these events help connect people. Today's talk involving speakers from Oxford University, Federal University here in Curitiba, and São Paulo University is testament to that. Competition law is, after all, of global importance. I would like to thank all the speakers taking part, and special thanks to Ariel, our keynote speaker, for accepting our invite. It's a huge pleasure to connect the UK and Brazil in another bilateral dialogue. As an economist, I'm certainly not an expert on competition law, which is why I'm excited to take part and listen to our expert speakers here today. I do know, though, that as competition law seeks to maintain and promote market competition by regulating anti-competitive conduct, it's extremely important to our market economies and therefore economic development and the rule of law, protecting the interests of consumers and ensuring that entrepreneurs have an opportunity to compete in the market economy are without doubt important objectives. Looking at this from a British consulate perspective, the UK is and will continue to be one of the preeminent legal centres in the world. The UK legal sector contributed around £26 billion to the British economy in 2015, which is double the sum from 10 years before that. More than 200 law firms from around 40 jurisdictions operate in the UK, and more than a quarter of the world's 320 legal jurisdictions are founded on English common law principles. As we know, English law is the most popular choice of law in the world for commercial contracts and governs about 40% of all corporate arbitrations. UK law firms and chambers offer international networks of talent to help firms navigate cross-border deals. As one of our greatest exports, we want to ensure that legal services remain at the very heart of our future as a global, outward-looking, free trading Britain. That is why I'm honoured to help organise and promote today's event, connecting British-based and Brazilian experts in key areas of debate in the legal sector. Thanks once again to everyone watching at home, in offices, and tuning in. And without much further ado, I will hand back to Pratoras. Thank you very much.
So thank you very much, Mr. Patterson, for inviting us, for being here today, for presenting this webinar. And since everyone's here to listen to our key presenter, I would like to ask Professor Ariel Ezrachi to begin the presentation about digital markets and competition law. Thank you very much.
Thank you very much. Hi, everyone. It's a real pleasure to join you. And what I would like to do is to use the time we have to explore a little bit the areas that are unique about the digital economy, and in many ways to explain why this is such an important period when it comes to our policy and law, and what makes it also extremely challenging from enforcement perspective. So I'll share my screen now, and so we can all see the PowerPoint presentation. So give me just a second, please. Okay, and that's the presentation. So hopefully you all see the presentation, and let me begin. So the story that we have is an interesting story, and I think it's always important to start that story while looking at the positives of the digital economy. Because from that moment on, we will very quickly slide to focus on what is wrong in the dynamic of competition when we think about digitalization. So it's quite important to begin with highlighting that, of course, we all benefit from the digital economy. It is something that transformed the way we communicate, the way we buy, the way we shop. Everything is so much easier, the flow of information, the flow of business, the flow of data. So there is no doubt that the digital economy has benefited us immensely. From a competition law perspective, therefore, the counterfactuals are not, should we go back to brick and mortar dominated economy? We are not asking whether we were better off than 20 years ago, because of course we are. The question is whether what we see today in the digital economy is an efficient market in which the dynamics really work. And this is where the story of virtual competition becomes relatively complicated. So if you look at the first slide, what you see are some of the key indicators that shape the competitive dynamic as it is at the moment in the digital economy. And each and every one of those elements is not unique on its own. But the interesting thing is that the aggregated effect of those elements create a market dynamic that is very different than the market dynamic that we were used to in a brick and mortar reality. So some things are quite obvious. The first one is network effects. We're all familiar with direct network effects, with indirect network effects. The idea that a certain service, a certain platform becomes much more valuable the more people join this. And in that reality of the online digital environment, network effects are really central. They connect people, they generate massive efficiencies, and this is why, of course, platform became such drivers to our online economy. In that environment, data is a key input, but more important than big data is the understanding that big data and big analytics give you together a significant advantage. So algorithms, data collection, data analysis enables us to identify certain patterns, identify certain or achieve and obtain certain insights that we wouldn't otherwise have if it wasn't for that significant scale. Another thing which is a characteristic of this environment is the asymmetry of information. Each and every one of you, when you go online, have good information, but relatively limited information in comparison to the information that is held on the other side when we deal with the service provider. The service provider is more sophisticated than most of us, has better tools than most of us, and therefore it can engage in tracking, harvesting of information, targeting, manipulation. And all of that environment gave rise to gatekeepers, to key platforms, key operators that naturally, because of the excellent services that they provide, became the gatekeepers. A lot of our activity is channeled through those gatekeepers, and that, of course, give rise to market power. Sometimes power which is harder to identify if you use traditional methods, but when you ask yourself, who are we using to access certain information? Would we switch? Would we multi-home? If the answer is no, there is some element of power here. And the last characteristic that I think is really important when you think about the digital economy is the fact that some of these markets are characterized by winner takes all or winner takes most of the market. So the combination of all these elements that I described help tilt the market and tip it in favor of a given company. And that company then benefits from greater economies of scale, better network effects that enhance its market power, and so forth and so forth. And what happens is that then it is much harder to destabilize that company. Disruptive innovation might destabilize them, but as we'll see, this is not always the case. In this environment, the question is whether the dynamic of competitions are still as we recognize them from brick and mortar. And one thing about this environment is that it is a platform environment. If you look at this slide, it gives you an idea of the power of the platform business model. Now, to be clear, there is a reason that this business model is so powerful, because it is so efficient, because it is so good, and we benefit from it. But you cannot hide from the fact that 7 out of the 8 largest companies in the world are platforms. So it gives you an idea of how we moved from an environment in which the internet was based on a concept of democracy, decentralization, into a market reality which is very centralized, very clear network effects that tip the market in favor of several companies. And then the question that we have is, are we happy with that? Is this okay or not? So there is a massive policy debate that is taking place around the world. And that policy debate starts with a basic question: is there a problem? And it's a real question, because you can find people that will tell you there's absolutely no problem with the online environment. It is the best environment you can imagine. If you believe that there is a problem, then the second question to ask, is this a competition problem? It could be a privacy problem, a data collection problem, maybe consumer protection problem, but is it something for competition law to address? And part of the answer will depend on what is the scope of competition law. Different jurisdictions will have different scope of competition law, either in the letter of the law, or sometimes the different scope will be the result of the interpretation of the law. Some agencies take a very laissez-faire approach and in a way narrow the practical application of competition law. Other agencies tend to be more interventionist because they doubt the ability of the market to self-correct. And if you believe that there is a competitive problem, are your competition laws sufficient? Should we amend the law? Should we change our enforcement approach? And to what extent this is something that competition law can effectively cope with? Or should this be something that we deal through regulation, through ex ante measures? So a very interesting policy debate that has been extremely interesting in the past 2 years, because we had so many reports. You have some images here of some of the key reports from last year. And this year we already have recommendations, we have consultations. So this is a very lively environment. And what I would like to do with you is to highlight some of the more interesting areas. There are many areas, and we cannot cover all of them, but to cover some of the interesting areas of anti-competitive activities. But there is a question mark here on this slide, and there is a reason for that. Because for each story that I will tell you, I want you to think as policy makers and ask yourself, is this anti-competitive? And if it is, what can I do in order to remedy this? And this is really the challenge that we face when we think of it from a competition policy perspective, when we discuss this with enforcement agencies. So first, I want to share an example that has to do with collusion. And this is an example that is based on my book with Professor Stuckey, Virtual Competition. And in that book, we look at the way in which in digital markets, the invisible hand, that hand that we all remember from Adam Smith scholarship, the invisible hand of competition that is supposed to facilitate the market dynamic is being replaced with a digitalized hand. In a way now, the way we interact, the way prices are being determined is governed by algorithms. And we ask, to what extent is this a problem? To what extent this is a game changer? So the classic scenario, very simple scenario from a legal perspective, is when you'll have a cartel between entities, and that cartel will be determined and agreed by the humans. The only difference here is that you deploy algorithms in order to monitor and police the cartel. So there's no problem in proving the cartel. The interesting thing here is that because we are using online instruments, there will be much less communication and interaction between us. What will happen is that we will engage only in the initial agreement, and then we automate everything. So we have a few examples, but the basic idea is that you know that I have an algorithm that samples your website every hour. I know that you have the same algorithm. The idea that you have a good monitoring instrument already deter me from cheating on the cartel. And if I do cheat, I have very little time to benefit from me dropping the price and trying to sell more units, because your algorithm will immediately identify that, and usually there will be an automated response where the price will be dropped, so I'm punished on my attempt to cheat on the cartel agreement. And we have cases here because this is not as challenging from a legal perspective. Let's move one step up. Hub and spoke conspiracies. In a hub and spoke scenario, here it becomes a bit more challenging for us from a legal perspective. A lot of the prices that you see these days online are dynamic pricing. Dynamic pricing are pricing that are very efficient because they are being determined on a minute base based on the level of supply and demand on the market. In a way, this is a much more efficient market. And this is why sometimes when you want to buy something, let's say on Amazon, it might cost $9 at 1 hour, and maybe 3 hours later, it will be $8, and then it will be $12. The algorithm adjusts all the time to the market characteristics. Now, a lot of companies do not have the facility in-house. What do? They outsource the function of dynamic pricing to a service provider. I think there is someone with who is not muted. So if you can please mute your microphones, because I hear an echo, please. Thank you. So if you use then someone to determine the price, that's absolutely legitimate. But the question is, what happens if I have a website where I sell office equipment and I outsource that function to a service provider to determine the dynamic pricing, and someone else does the same thing, and another one? You may reach the position that you have a single algorithm that determines the price for the whole market. And whereas that algorithm every time is supposed to look outside and identify the market dynamics to determine my price, that algorithm doesn't have to do that anymore because the whole market resides on the same server. And we have a nice example from Rotterdam in Europe, a company called A2I that manages all the prices for all the petrol stations in Rotterdam. Now, ask yourself, if the same algorithm determines the price based on what that algorithm thinks will be the price decisions of other players, but those price decisions are determined by the same algorithm, do we have here a de facto hub and spoke collusive framework? And if we do, should we make it illegal? So these are really interesting questions. And some of you might think that's very simple. Yes, it should be illegal, but not necessarily. What if that company that provides a service says that they have firewalls, so the algorithm every time is blind to the rest of the information? Should we trust them? Should we believe them? So we are moving more and more into a reality where pricing decisions are not the result of just dynamic behavior on the market, but the result of interaction between algorithms. And sometimes those algorithms will have a lot of the information which they control. The next level of complexity in pricing decision is when you have tacit collusion. Now, tacit collusion is an economic phenomenon. It is perfectly legal. It is about us facing price alignment, which is the result of natural reaction to market characteristics. This will happen in oligopolistic markets where you have very specific market characteristics, barriers to entry, good transparency, ability to detect variations, abilities to react. When humans engage in tacit collusion, and collusion sounds a little bit illicit, but it's not. This is conscious parallelism. We do not condemn them. We understand that sometimes humans will react to price, and if the market structure is such that the market will result in a higher price, so be it. So whereas tacit collusion is something that we condemn under merger regulation, we do not usually condemn it under agreements as an illicit agreement. But what happens when instead of humans, you deploy algorithms and you teach them the model of tacit collusion? You basically create a situation where you take a market that would not normally have tacit collusion and you push towards it, leading to higher prices. There's no communication, but you're using an algorithm that is taught to react to price reductions and punish, but follow price increase. Again, it is an uncharted area. What should we do? Should we make this illegal? And where is the dividing line between human behavior, which we accept as possible, and enhanced algorithmic behavior? And even if you say that you will not allow humans to instill the logic of tacit collusion in algorithms, then you face another problem of artificial intelligence. At the beginning, when we released the book on virtual competition, some people argue that this is impossible. Algorithms will never engage in collusions. It will be very easy to detect that. What you have in front of you is an example by a group of very talented Italian economists that showed that if you take Q-learning, which is a simple artificial intelligence, a simple form of artificial intelligence, and you deploy them on the market with the right conditions without teaching them anything, they actually realize that they should charge a price which is higher than the competitive price. In other words, in a world where algorithms determine the price in the future, those algorithms will learn on their own that if there is a way to optimize the price by increasing it legally, they will do so. And what you see here, the example, is how the algorithms moved to a higher price. And when one of the algorithms was forcibly pushed down, the other algorithm reacted to punish it, and both of them then returned to the higher price, the price previous to the shock. That's remarkable because it tells you something about how we moved from a natural dynamic of competition to an algorithmic-driven competitive markets where price is not necessarily the result of the dynamics, the natural dynamics that we imagine. So that's one story. Another story that is relevant to us when we think about the digital environment is that of tracking. Now, you're all familiar with all the stories about tracking. The important thing, really the bottom line here, is the understanding that the environment in which we spend most of our livelihood, think especially now with COVID-19, how much of our time we spend online, how much do we purchase online, is very different from the high street. Because whatever you see on your screen is not a reflection of the high street. The prices you see are not the same prices that someone else might see. In a way, what you have is an environment where algorithms are using data about you that was harvested in order to assess your reservation price, your willingness to pay. And they would then serve you with prices, with advertisement, with little hints that would maximize usually the profit of the seller. In a way, I don't know how many of you remember the movie The Truman Show, but it's very much like The Truman Show. You can still live a very happy life, not knowing that you're walking on a path that was designed especially for you. So while you have a sense of autonomy, you might be going through a path that I designed, leading you exactly to the website that I want and serving you with exactly the same prices. If anyone have ever experienced putting something in your basket, then leaving without purchasing, getting a pop-up window that tells you come back, giving you a discount, these are all reactions of algorithms that assume that your reservation price is certain, your willingness to pay, gave you a certain price. When you left something in the basket and you left, they realize that maybe your willingness to pay is lower. Hence, they give you a lower price. They're trying to correct. If you go for a website, I'll give you just one very quick example. Dynamic pricing companies, if you go and you ask them to engage in dynamic and personalized pricing for you, one of the simplest algorithms that they will deploy is that if you arrived to the website through a search engine, the price you will get will be the competitive price, because the assumption is that you are aware of the outside options as a customer. But if you're a loyal customer and you went directly to the seller website, then you will be rewarded with a higher price, because the algorithm understands that you're not aware of the outside options. So it's a reverse logic from what we're familiar with. And that logic is become possible because price can be determined on your postcode, on the computer that you're using. Are you using a simple PC? Are you using a branded computer? It can be determined based on your search history, your location. So many variables can play a role, and of course your search history, in determining how much you will be charged for something. And there is a whole area of behavioral economics where we can show how certain biases can really help us. If we feed into those biases, we can really extract more value from you as a customer. The bottom line is the Truman Show. What might seem as a competitive environment to many people is an environment where you can discriminate. Remember the original question, though, is this a competition problem? You might think this is unethical. Should we make it illegal? At the moment, it's not illegal. You're unhappy with that? Well, tough. That's the story. So here, again, very significant policy questions. Now, it goes even beyond that, because if I control your interface, I can determine where you go. I can experiment every minute by changing the font size, by changing the location of links. I can every time measure how you react until I perfect it. I can create friction when you want to find something else. For example, if you want something completely different in Europe, data and privacy protection, every website needs to ask me if I'm willing for them to install cookies. The easiest thing for me is to press I agree. If I want to disagree, they create friction. What does it mean? I need to do something like maybe 6 or 7 clicks. I need to go somewhere, to scroll down, to find something else, to say no, 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 save. That is a very simple example of creating friction to prevent me from doing one thing. I have to have a real incentive not to go into the agree and just end it there. So there is a lot of power that resides with those that actually are the gatekeepers. To give you just an interesting example, today there is an ability based on your text, based on the language that you use in social media, for algorithms to identify not only basic things that are relevant for advertisements, even to identify emotional state. And you can be classified. Do you feel insecure, stressed, silly, useless? It is at that level of refinement that information can be established about you. And by the way, not just about you. Even people that are not on Facebook, you can establish a profile by knowing enough about people around them. So it is a highly sophisticated mechanism, very different from the market reality that we know. And it gets more and more complicated, of course, if you think about things such as the digital butlers, all the automated helpers that you have. Because whereas now, when you have the search results online, you can decide and go elsewhere. Even if it's a bit harder, you can say, you know what, I'll go to page 3 on my favorite search engine and look for something. Once you move into voice activation, you will usually get only just one result. And in a vertically integrated provider, that result is likely to be the result that serves that provider. So in a way, when we use those gadgets, we already send a signal to the provider that we agree to move out of the market into a situation where we're locked in. We agree to extract ourselves out of a market and put our trust in that supplier. Whether that supplier will give us the competitive price, the best service, is quite an interesting question. There is a cost for messing with us. There is maybe a cost when it comes to the brand. And just to give you an example, twice Amazon was accused of engaging in personalized pricing. They apologized twice and said they will never do it again. I assume they don't do it again. I have no reason to think otherwise. But you see, there is sometimes a cost to do that. On the other hand, Uber, for example, a few years back, had no problem saying that they determine the price based on data that they hold about you. I don't know if they do it still today. Some companies became much more sensitive and much more sophisticated now in their messaging because they are aware that many of us feel very uncomfortable with that. The reality, however, just so you know, is that there is a very big business on the other side of the market of analytics and personalized pricing that does exactly that. Okay, let's move to another story. We told the story of collusion. We told the story of discrimination. Let's talk now about the whole data harvesting industry. And here, this brings us to cases that are really high profile because you all hear all the time about the platforms, how much information do they have? So first thing for us to identify and appreciate is the fact that most of us hold a tracking device in our pocket. And there are only two providers. You're either on Apple or on Android. There are two ecosystems. And most of us will have one of those ecosystems in our pockets. And that ecosystem already tells you a story about where the power resides in our infrastructure. The more we move to mobile, the limited number becomes of platforms that can really control what we do. Second story here is the fact that everywhere you go, even if you opted out from many tracking, every website, every application will have third-party trackers. These eventually are managed by very few companies, the usual suspects. The interesting thing for you to know is that information is harvested about you every time. There is an ongoing degradation of privacy, and it's very hard for us to keep updated and to keep being knowledgeable about what exactly is happening. None of you will know how much information is actually being taken from you at every given moment. And a very simple anecdote, there used to be a service called Disconnect, a company that was created to tell you every time an application is harvesting information from you and basically selling it. And that application, this Connect application, was, of course, thrown out of the ecosystem. You will not find it if you go to the online shops anymore. Why? Because it went against the narrative, against the business model that runs the online environment in which we operate. By the way, another application, Flashlight, if you downloaded the Flashlight application, without telling you, that application harvested all your information, even when the application was off. So just to give you the two extremes and give you a hint of how the environment looks like. Now, in that environment, it is only natural that a lot of the firepower is addressed at the platforms and the market power they have. Some of the key stories that we have, of course, we had in the EU 3 Google decisions, very powerful decisions on appeal, very interesting. We have the Bundeskartellamt investigation in Germany that went through several cycles on appeal when it came to the interim measures, extremely interesting. So Google is about leveraging market power. Facebook, it is about downgrading privacy setting, basically not allowing you as a user to refuse information being merged between Instagram, WhatsApp, and Facebook. Amazon investigation ongoing about Amazon being vertically integrating, making use of its preferred position to know more about sellers, and in a way cannibalize that's the argument, cannibalize their sector. If there is profitability there, pushing them out and replacing them with a Prime service. An Apple investigation, again, in terms of the tax that Apple imposes on streaming services and whether Apple favors its own operation. Very challenging questions here about what does this mean when it comes to vertical integration online? What does it mean when it comes to self-favoring? Does it mean that a company cannot favor its own operation? Does it mean that we have to give the same conditions to everyone? What is the difference between innovation that serves consumers and between anti-competitive activity? What if I introduced a certain innovation? That innovation meant that a less advanced competitor was pushed out. Is that innovation or is that exclusionary practice? Very difficult. And for those of you who are interested, if you look at the debate, you can see that in the background there is an ongoing fight where different entities, different groups are trying to capture the debate. There is a lot of lobbying here, a lot of money. That's quite natural. Those of you who saw the public hearings in the US probably were aware of all the tensions there. And there is a real attempt here to capture the debate. Is it about us benefiting from digitalization, or is it a debate about us actually now becoming really the subjectees of the exercise of extreme market power? Extremely fascinating, not to mention the questions of what it means when it comes to mergers and takeovers. Should we be in favor of those activities or not? I'll give you just one example very briefly, and this is from a book that Maurice and I recently published. It's called Competition Overdose, and there we look at the dynamics of competition. And one of the stories we tell there is how what makes platforms unique is that they don't only benefit from market power, they actually control the competitive process. And this is something that we rarely experienced before. So we always had very large companies. We had large entities, but we didn't have large empires. So if you think, for example, about an operator of an ecosystem, you have access to consumers, to users. You have on the other side, the service providers. What you do is you create an autonomy, and competition happens within your autonomy. So you get to set the rules of competition. You basically get to determine what will be the dynamic of competition on your platform. You get to determine what is the tax that is being paid on your platform. You get to determine how much information in your reality is being harvested from users. So what usually was the function of a market now happens in an ecosystem that is completely controlled. So we have those empires, and those empires, because of their profit motive, are really distorted. So a lot of the empire power go into creating a culture where what you need to do is hook the user, increase the usage time, and extract as much data, because you need that on the other side of the market in order to generate income. So if you have an application, for example, and you want to sell it online, if your app does not harvest data, you will be very low in the app shop because you're not part of the game. If you want to be pushed to be part of the system, the winning system, you have to play the game accordingly. And indeed, you will get training and you will get tools in order to embed as many harvesting instruments in your application. The whole market, therefore, is created in order to extract more data from you. So very interesting, as we're not just talking about market power, we're talking about those that control the ecosystems. So that's the story of competition. And you have a lot of enforcement actions. You have a lot of debate where people argue, oh, you're doing too much, you're doing too little. Is it over-enforcement? Is it under-enforcement? But you also have an interesting policy debate about whether competition law can really be the right remedy here, or whether competition is just too slow, too reactive in nature, and there is need for regulation. Now, not regulation in the sense that we want to regulate markets and regulate price, but regulation of data, regulation of platform to business activities, platform to user activities, e-privacy regulation, these type of regulations that create clearer boundaries as to what is acceptable and what is not. So instead of having a reactive approach that you run a case, and those cases are very difficult, competition agencies usually take risks when they run novel theories of harm, and that deters them from running these cases. So if you really want to remedy the market, you need to get the incentives right. Regulation can be a solution. There is now an ongoing consultation in Europe that asks, for example, what type of regulation should we have to deal with very large platforms? Regulation has a cost, so the idea is let's only apply it to very large platforms. What should be their responsibilities? What can they do and what can they do? Or, for example, Europe wants to advance now something that we have in the UK, which is a form of market investigation. You look at the market and you try to correct the market structure, the market dynamic, without arguing that a certain firm abused its power. So a lot of the debate now shifted from saying there's no problem or there is a problem and competition can remedy it to saying there is a problem, competition can deal with some things, but competition is reactive. And the remedies many times, although we read about them in the newspapers and there is always a lot of debate about them, they don't really affect much the large companies. So what we need is an ex-ante regime. We need to deploy regulation. And again, it needs to take us back to the origins. There are risks in those policies. Every intervention can have a cost, the cost of over-enforcement. But lack of intervention can have a cost of under-enforcement. So again, in this game, the aim is to try and hit it exactly right. But you have to be mindful of government error, government failure. Governments are not always the most efficient entities, and sometimes they get the regulations wrong because of capture, because of lobbyists. So it's quite of a messy environment, which explains why there is such a heated debate and when we look at the online environment. And I'll leave you just with final reflections. How competitive do you think the online environment is? Some companies will say it's the most disruptive environment. Competition is a click away. Some people will say, well, the competitor might be a click away, but competition isn't, because you designed everything to prevent users from clicking. To what extent we should still rely on the invisible hand, or should we accept that now we work in an environment that is artificial in many ways? So we need to adjust our theories. We need to put more emphasis on asking economists to rise to the challenge and look at dynamics that are very different from the assumptions that they had, assumptions that, to be honest, of rationality that don't exist often also in real brick and mortar markets. And it goes beyond just the markets for goods. It's also about the markets for ideas. It is about the news you read. It's about algorithms that determine your eco bubbles. It's about democracy. So there is a lot of lot of issues that link to our stories of markets. So you need to ask yourself, do you believe that what you have at the moment, the rules that we have, be it competition law or regulation, serve you, protect you the way you believe the state should protect you, or do you believe that they protect others? And that's a challenging question. I'll end with that. Thank you very much.
Thank you very much, Professor Ariel. It was amazing. I think I've learned a lot. I think everyone that's listening and watching actually learned a lot as well. And we are accepting questions from everyone, including the professors. And I would like to start with my own question, because I was very interested when you talked about the Truman Show. I love that movie. It's one of the best movies, I believe. It's really nice with Jim Carrey. And I was thinking while you were talking, do you believe if we fix our privacy issues, it will fix some of our competition issues? For example, knowing less about their customers, those big enterprises, those big companies, could mean less personalized pricing. And for example, I usually look for plane tickets online, and then I use that anonymous window because I know they cannot find out how many times I've been looking for those prices. And do you believe so that customers can fight back those personalized pricings, because we do have options without the need for new laws and new regulations? I'm usually against new laws and new regulations, especially because we do have an outside market. Do we need to be so well taken care of, or can we go on fighting back with everything that we can, including the anonymous windows to look for plane tickets, for example? So thank you very much, and please leave your questions, everyone, so I can read and I can bring everyone that's watching us on YouTube. Thank you very much.
Okay, I mean, it's a good question. So I'll tell you what. When you fight with analog means a digital environment, that's what you're doing, okay? And I think the best way to answer that is to tell you that the casino always wins, okay? So, you know, when you go to the casino and you're like, yay, you know, I made $1,000. Yeah, I mean, that's great. But overall, the casino always wins. Now, the thing that you ask, which is interesting, is to what extent should we be protected? And this is one of the arguments, the key arguments that is advanced by those that seek no intervention. They say, you're paternalistic. Stop doing that. The customer is brilliant. The customer is smart. What you're doing is actually distorting the market. And these are good arguments. Personally, I believe that they're not true, because the whole idea is you interact with a website once every now and then when you buy a ticket. On the other side, you had behavioral psychologists, engineers, people that thought about it again and again, experimented with how they can affect people like you, because you're grouped in a very specific group, how they can affect people that look just like you, but with a slightly different income, people that look just like you, slightly different income, also different postcode. So your ability to fight is very limited. Now, then we go into ethical questions, because also when you go to a market, the seller doesn't tell you that that picture is worthless. The seller tells you that's $50, and and you bargain in a traditional market. So we don't think that in a market suddenly the seller will have a responsibility to tell you, you know what, I found it this morning on a pavement, it's worthless, take it for $1. Of course, we don't think that should be the case. So we're on the spectrum between protecting us to the extreme, but also allowing a market to operate. Do we want to be? And it's a really difficult question. Do you think that if you were going online and you were told the price that you received has been designed personally for you, okay, using information about you, is that something that you should know? Should you know that the average price for a ticket today was 30% lower than what I'm offering you? I mean, I don't know. And different people, and the amazing thing, I'll tell you a story, which I always find amazing. When you speak about discrimination, so I do a lot of trainings for different groups. If you train economists on the area of digitalization and you ask them about discrimination, they will say, I don't see the problem. Because they were conditioned and educated for such a long time that discrimination can be, of course, efficient. We all understand discrimination can be good. The problem here is that we have absolute discrimination. But they will say, I don't see the problem. The market is efficient. Distribution of wealth in society is not my problem. You speak with competition lawyers, they feel uneasy, but they don't have all the background of the economists, so they go in two directions. You speak with students or people that have not gone through the pipeline that all of us went through, and they outraged. I mean, as far as they're concerned, they're going to just tell me who stole my money. I mean, this is horrible. And you tell me that the state does not protect me, and they know that. So I mentioned that just so we all understand that our perception of right or wrong is exactly that. It's our perception as society. This is why these are difficult policy questions, because these are policy questions that I dare to say you'll give a different answer in the US than you would in the UK. You know, drip pricing in the US, where you have the casinos in the US that charge you in Las Vegas resort fees. So we covered that in Competition Overdose. And when the FTC went after the casinos lobbied and they won. The FTC had to allow them to basically sell your room for $20, but then when you get to the hotel, you're charged $200. That is illegal in other states. Now, in the US, they won it by saying that this is competition, this is free market, and this is about not being paternalistic. I don't know. You might say that's the right thing, because consumers are so bright that they know that when they go to Las Vegas, they're going to be hit. So they just hit one more time. But if you book a room in the US at a hotel on the strip in Las Vegas, you will pay what looks at a lower price, but eventually a higher price. If you book it, for example, in Australia, in Las Vegas, but you book it from a website in Australia, they are bound by Australian law that will say, tell them the actual price. Stop manipulating them by having very tiny print. It's the same question in a different context.
It's sure amazing, Professor Ezrachi. Yes, we do have those questions, and we can actually be elsewhere, right? But I think those regulations and those laws can actually help a lot, especially like not every consumer has enough information. Like you said in the beginning, the asymmetry of information is also key in those digital markets.
It's interesting, if I just may say, it is actually the poor that are being deprived mostly, because the rich usually will have the technology to try and address these issues. So what you find in the digital economy is that it has a reverse effect, just so we'll know.
Thank you. Thank you very much, Professor. So I would like to ask if any of the other professors want to ask some questions, since we have Professor Ezrachi here today, Professor Vinicius, Professor Juliano, and Professor Eduardo. Okay, I think
maybe we should go back later to debate, maybe.
Okay, thank you. Thank you so much, Eduardo. So I would like to ask Professor Juliano Maranhão, who is the Professor of Law at the University of São Paulo, to start his presentation. So thank you for joining us, Professor Juliano, and let's hear from you. Sorry, Professor Juliano, you are muted. Okay, good.
Thank you very much, Vanessa. First of all, I would like to thank Professor Vinicius Klein for the kind invitation for this debate, which it's a pleasure to join. And I would like to compliment all the other professors and members of this panel. And it's a pleasure to discuss these matters with me. And I would like first to congratulate Ariel for his excellent presentation, from which I will profit from, since I will use some of these concepts. Let me share my screen. Okay. So is the screen fitting all right?
Yes.
Are you seeing everything okay? Okay. Okay, my discussion will be based on this idea of sovereignty that which is built in constitutional democracies around the ideas of a sovereignty of the citizen and the sovereignty of the consumer or the data subject more recently as tools which are built by the law, as tools to countervail the problem of concentration of power. And this concentration of power has basically three dimensions, important dimensions at least: the concentration of political power, the concentration of economic power, and the concentration of informational power. Of course, these we have political power as the concentration of the decision about the common good, economic power as a concentration of the decisions about economic variables, such as what to produce, how much to produce, how to charge about this production, and also the informational power, which is basically the power to determine the content and opinions in the public sphere. These three dimensions of power are interconnected. One feeds the other. So it's well known that economic power may lead to reinforce some groups of interest that might influence the political arena. And the same goes in the other way around. Political power may brings also favors economic power. On the other hand, informational power, the control of public sphere, is an important tool with respect to political power, and also the other way around. And finally, economic and informational power are also interrelated and interconnected to the fact that the supply of information is a market of its own. So the concentration of economic powers may lead to the concentration of informational power. And since information is an important asset in modern economy, the concentration of information leads to the concentration of economic power. So how to handle this? The law in constitutional democracies provides regulations to try to balance and countervail this concentration of power in these three dimensions by trying to build those three figures and try to make these figures, these ideals, to countervail these powers. So these three figures are in the political arena. The idea of the citizen, which is built through many rules regarding the rule of law and the control of the political activity or transparency of the activities by public officials. So there are many rules regarding this environment. There are also in the economic field the ideal figure of the consumer as a sovereign, which is also built through antitrust and consumer protection laws. And also you have then this dimension of informational power. And what I want to emphasize here today is how the balance between these three dimensions of power is affected when we shift from the society of organizations, where you have the press as the main vehicle of information in the public sphere, and then you move from the society of organizations to the network society in the environment of in the digital environment, or the environment of internet, mainly internet 2.0. So when when you move from the position of citizens as spectators of these providers of information, to this new environment of data subjects in the internet. So when we are seeing nowadays this shift in the dimension of the informational power, and what I believe is that we go from reasonably balanced scene regarding these three dimensions of power, regarding the relation with law enforcement, to an unbalanced scenario in the digital economy. So let me build on that. First, I will assess the society of organizations, where the relations between citizens are intermediated by organizations that provide in these different fields, political, economic, etc. They are the main actors. So political parties, economic enterprises, and etc. Economic companies, and etc. So the relation between in the society of organizations that deals with citizens and consumers, the relation between economic and political power is clear. Actually, the rise of antitrust law is linked with the idea that the political powers of trusts should be controlled, and then the idea of citizen sovereignty is through antitrust law and consumer protection law, they build this ideal of a consumer sovereignty, where the consumer must prevail in the choices that will determine, in the end of the day, what's going to be produced, what's the price, etc. So when this idea of consumer sovereignty is also in the relation of economic power with political power is intrinsic there. As you see, for instance, the first punishments in antitrust law were directed to labor unions. So this relation was quite close, and then the development of antitrust has brought with those all the technical theory, those words apart. But in the end, there is a picture of Daniel Daimler's work, Concern und Moderne. This is a very interesting book that shows how the idea of that trusts must be controlled in the beginning of the 20th century and end of the 19th century was built in the public sphere of information by the effort of publicity and the press that built some images like the image of the Kraken. So information in this environment is also important, both to face political and economic power. With respect to political and informational power, then what we have in this field is that there is law enforcement on media companies as organizations that provide information this law enforcement is built mainly around the liability of media companies. So media companies are responsible for the content that is provided in the public sphere. There are professional rules or a culture by the press and the media that controls the content, controls diversity of opinion, control also the verification of sources. And there is also transparency where you can identify what is independent content, what is editorial, what is publicity, and etc. And there are also rules regarding political campaigns. So the relation between the political dimension and informational dimension in the society of organizations is regulated by the law to an extent that it reaches somehow an equilibrium that controls the definition of content in the public arena, in the public sphere. Now, with respect to the economic dimension and the informational dimension, when we handle the society of organizations, and there is also a balance, because what we have here as economic concentration is nothing but the concentration of the production of content. So media companies are just the suppliers, the spectators are consumers, they consume information, and this makes a smooth transition and application, or a smooth translation of antitrust and consumer protection law to the field of information. Since you have companies that provide as suppliers information, then antitrust laws and rules fits nicely to this framework, as we had experienced several applications of antitrust law in the media market. So here we see a balance between the economic dimension and political dimension, the political and information, and the economic and the informational dimension through a framework of regulation, the regulation of the media, the traditional media, the regulation of antitrust and consumer protection, and regulation of the public sphere in the political arena by the rule of law. So what happens then when we change the dimension of the informational dimension within the new technologies of communications and the new media, digital media of communication? I believe that there is these transformations create an imbalance between the regulatory framework that used to control these three dimensions of power and use to try to build this ideal of sovereignty of individuals. So the main transformation is about the digital technology of communication, and we have first an imbalance between the informational dimension and the political dimension, considering that with respect to law, first we have safe harbor for platforms as intermediaries regarding the content produced by users. This is something that is being broadly revised, mainly in Europe, but in other countries. And also here in Brazil, for instance, there will be the Brazilian Supreme Court is going to decide whether the safe harbor, which is present in our legislation of the internet, is constitutional. But what we have is a much lower degree of liability of the platforms if you compare the degree of liability of traditional media in the society of organizations. We also have a decentralized content production, so we don't have professional or ethical control about its content, about its source, about the fidelity of the information. We also, as Ariel has explored, the working of algorithms that filter the content in order to create engagement. So what you receive is led by algorithms that they are not bad, but actually they operate efficiently in order to provoke engagement and therefore collect data to get more efficient and also to provoke more engagement. So there is this cycle which leads to the so-called echo chambers and engagement, and that so that individuals receive the content they are willing to engage with and they are willing to agree, what creates this phenomenon of political polarization, and leads to the question about the need to regulate networks, social networks. This is a particular discussion which is presently very hot here in Brazil. There has been regulation in Germany, which is nowadays under revision. So, but actually, you have, for instance, here in Brazil, a field where there is no regulation at all. There is also the regulation of campaigns is also opaque in this field. So what we have is that there is an imbalance in the construction of the rights of the citizen in this relation between political power and informational power. Data protection law fulfills an important role here in order to try to rescue information on self-determination by data subjects. But the question is whether really data protection law is effective, considering that we face a large concentration of economic power in platforms, so that this reduce the choices which are made available for the data subjects. And this brings us to the relation between economic power and informational power in network societies. In this relation, we lose the clear identifications of consumers with spectators, producers, the media companies as producers or suppliers of information, because now in the platforms, what we have, platforms are not really suppliers, they are intermediaries, but they create an environment in the code where the information is provided. The data subject is not anymore just consumers of information. They are not spectators, they are producers, they produce content, and there is then a new economic model which was brilliantly explored by Professor Ariel, so I'm not going to spend time here. There is a new economic model based on the collection of data to produce to increase efficiency, that leads to more collection of data due to network effects. This leads to a concentration of power, and then this becomes a problem to the effectiveness of the enforcement of data protection law, since since the data subjects will not have much choices about data processing policies, since there are just a few platforms that control the digital markets. So how to enforce data protection law, dealing with the economic powers by platforms? Do data subjects have a choice about data processing? Do they really have autonomy? And this comes not only due to the reduction of choices given the market power of platforms, but also due to the algorithms that, as emphasized by Professor Ariel, due to algorithms that manipulate consumers' desires. So this leads us to an unbalanced picture where this is the Economists in 2005 had this headline, "Power at Last: How the Internet Means the Consumer Really is the King and Queen." So this was the expectation about the Internet, And due to all these processes and characteristics that were emphasized by Professor Ariel, we came out actually to a digital kraken, led by 4 major companies on the internet. And so how can we handle this? How can we really ensure consumer sovereignty and data subject sovereignty by means of law, considering that we reach a scenario where there is an imbalance between the dimension of political power, the dimension of economic power, and the dimension of informational power. Professor Ariel considered that actually, he called our attention to the fact that it's not actually a matter of market power, but a control of ecosystems. And put it in other words, it seems that we are dealing here actually with the concentration, since data is the main concept. It seems that we are in a situation and a scenario where we have actually the concentration of data as the concentration of informational power, and we try to circumscribe this informational power by tools and concepts which come from the antitrust tradition. And again, the same question I would ask will that be enough? Will antitrust be enough to handle this concentration of informational power, which is now affecting the dimension of political power also, as we see in many countries in constitutional democracies? So I believe that the main question here is what we have to do. The question proposed by Professor Ariel was, should we count on competition tools, competition law enforcement, or do we need regulation of the technology? I believe that this difficulty is also revealed in how we have difficulty to handle the concept of data. The efforts to apply antitrust law concepts to this problem has been very unsuccessful, or only tentative, with several questioning, and it's very polemic. For instance, how should we understand what data is? Actually, we use many metaphors. Enforcers use many metaphors to try to handle data, applying some boxes that derive from antitrust methodology to try to handle this problem. For instance, one of the metaphors is you looking for the demand side, the side of consumers, is to call data as currency. So data is currency. This was used in Google's case, in Facebook's case. The metaphor was led to the point of saying, of using or trying to use a monopolist test by saying that trying to check a small but significant increase in data extraction. Or talking about, such as Pasquale, talking about privacy elasticity. These are attempts to extend or to draw consequences of actually a metaphor that equals data to currency. And on the supply side, there was also, in the scenario of antitrust enforcement, two different metaphors. The first one is that data is oil. This was mentioned in Google's case, such as if the data was a raw material that was used by Google to leverage its position to other vertically related markets. It's a sort of production input, so that the accumulation of data sources by Google was a sort of hoarding So they entered into vertically regulation markets, not really to make profit, but to ensure that they are going to collect data about vertically related markets, such as the news market or the market of price comparison. And by that means it collects more data so that Google can ensure its predominance in the searching market. So, and the other one is that data is asset. This was a metaphor used in Facebook's case. So in the Bundeskartellamt, you see Andreas Mondt, for instance, commenting that the solution was an internal divestiture of data sources. So when they considered that there was an exploitative abuse by not being clear about the use of the data, the connection of the data by WhatsApp with the Google's data. So a prohibition to join this data would be a sort of internal divestiture, where they see the data accumulation as a concentration of assets. So are these metaphors working? I believe that one of the problems is that these metaphorical applications of antitrust concepts, they have a limit, because there are many differences that sometimes are overlooked when you call data a productive input, or when you call data a currency, or when you call data an asset. So just to finish, I'll go through very, very quickly on these comparisons, because then we can notice that there are something wrong with these metaphors, and that may lead to equivocal applications of antitrust law, or also that may show that antitrust law and its concepts are maybe not enough to handle the problem that we are facing. So with respect to the metaphors of personal data as currency, we have clear differences. For instance, money has a nominal value which is intersubjective. The value of data is subjective. Money is uniform, but data, there are different types of data that have more or less impact on privacy. So health data is different from consuming data. Competitive price, we know how to calculate it, look into the marginal cost, so we can calculate and measure what is supra-competitive price. We can do that with personal data, although Pasquale had used these monopoly tests. Actually, we don't know what a supra-competitive privacy unfriendliness would mean. What is the competitive amount of collected data? And there are differences. Are we talking about consented data whose collection was consented, or whether the control of the purpose was well done? So the subject of data is much more complex. The supplier may claim money in exchange for services, but the supplier actually cannot claim personal data. The ways that the personal data are collected, therefore, are obliquous. And the consumer also cannot control what supplier does with his money, but that as a subject, in theory, may control the purpose of application of the personal data which was collected. Comparing personal data with asset or productive input, which is the other metaphors, we also easily check that these metaphors, doesn't fit actually. So when we go to the physical world, the assets or productive input, they are rival, while personal data is non-rival. You may use personal data without excluding the possibility of others using the same personal data. The consumer is independent from these assets or productive income input, while in the digital market, the asset is produced by the consumer. So what we mean by divestiture, we sell assets to other players. But what will be divestiture regarding personal data? Would that be that some should provide access to other players to this data, but then we would have a problem of sharing data, which is also a problem regarding data protection. Limit investment in asset input, and also in the end, the acquisition of assets behaves differently with respect to personal data. If we combine assets by two companies, we have the combined assets. But if we take a look at the Facebook decision, where the idea was it was not clear that the data of WhatsApp would be aggregated with data produced by Facebook. If we have consent by the user, if Facebook obtains consent by the user to use his data, and WhatsApp obtains consent, does that mean that there was a consent to use the combination of data between Facebook and WhatsApp? That's not actually clear. Should there be a new consent because the amount of data is now broadened? So these are just some points to show that these metaphors does not work properly, and this leads to difficulties in the application of antitrust law to handle the problems which are brought about by this new digital market. So maybe the effort should not be to try to transpose antitrust concepts to the idea of personal data, to the control of or maybe the idea will not be to try to consider informational power as a sort of economic power. Maybe it's the other way around. We are dealing with a new phenomenon with this informational power. It's mainly produced by the technology which is involved and a new digital economy. So maybe we should look for alternatives of regulation of this technology instead of just believing that the antitrust combined with data protection law would provide us with a solution to handle this and to face these challenges. So that's the main point. Thank you very much.
Thank you very much, Professor Juliano Maranhão. I think it was a quite interesting point of view. We received a lot of questions that I'll leave for later, since Professor Eduardo has to leave at 4 p.m. For a judicial hearing. So it will be nice to have this debate at the end with all different points of view. Thank you very much for your presentation. So to have more time to listen to Professor Eduardo, please, you have our word, Professor Eduardo Gaban.
Thank you very much, and I'm sorry for this inconvenient matter, but this is true. Let's see, let me see if I can share it easier. So bug, okay, now you let me know if you're seeing. Right. I will not go over all this, okay? But I will try to cover to add some points to this very interesting discussion, because, you know, I have no words to say how delighted I am to speak with Professor Ariel and Professor Vinicius, Professor Juliana, and Professor Vanessa. And again, I'm here to replace Professor Juliana Domingues, who had an appointment because of her really fresh nomination to be the Secretary of Consumer in Brazil. So thank you very much again. I'm really glad to be here, and I will split my reasoning into three parts. Okay, so I prepared. Okay, no, not this. Okay, I think, and I'm thinking of AI and problems involving AI for a while, and Professor Ariel tackled very precisely the matter in my point of view. Is it a problem of antitrust? What is it? A problem of law? Is it a problem of enforcement? Providing the agencies with more muscles to go after these violators? What it is exactly? And so in this journey through the nature of this problem, my first part, in the first part of my challenge, I go up some floors over the antitrust floor, or the legal framework building, if I may, to better understand if the problem should receive an external support. I mean, outside the legal framework, or if this problem should be faced by the legal enforcement itself, and precisely by the antitrust enforcement rules. Okay, so, and then the answer I think is right is that we should go outside the legal framework to see if we can find some ways to face the problem, because in my opinion, as Professor Ariel said, I think there is a problem. I'm a liberal, but I do think there is a problem, and you can see all over the questions, very interesting questions presented by the audience now. That, for example, the pricing methods narrowing consumers, I mean, to me, is a problem. And I'm not classifying myself as the youngers, not the antitrust lawyers, as Professor Ariel described it, nor the economists, but the youngers, the young people who feel outraged by this problem in pricing in the ecosystems, right? I've noticed this in person when trying to book flights many times. And the solution that I found was to use a VPN. Then the machines cannot find my IP, right? So, but I think there is a problem. And I think AI challenges the very nature of the matrix of the law. This is an axiom that I found it's very true. And the artificial intelligence challenges the logic underlying the legal requirement, or the legal theory, or the rule of law. So if we are dealing with something that challenges what we learned about law, the matrix of the enforcement, the theory on how to detect, to prevent, and how to punish crimes, right? And I include collusion or conspiracies in such a realm. So going back a little while, upon the legal theory of criminology, the very factor determined to prevent offenses is the trade-off inside the offender's mind in relation to the level of being detected and the weight of the sanction. So we learned this in law schools. And this is the recipe to prevent crimes. So this is pretty much the lesson of this guy, Cesare Beccaria. and this is what underlies, in my opinion, a great part of the legal regimes all over the world. Okay? And I like this one, you to use in classes to try to, show extremes under the deterrence and the utopia, right? So this is, I presume everyone has watched this movie, Minority Report. So effect of human life, however, is that the state or the law will always be delayed in detecting crimes. So as collusion, any crime. And for this reason, I like to use in classes this picture. But if we are much more into this side, the dystopia, and this side to AI terms. And I believe we are heading to this kind of, reality if we insist in applying the traditional matrix of law to detect and to punish crimes. Pretty much derived from AI functioning. But now what I'm talking about exactly. I'm talking about this. Nothing new so far. So, the basic and historical tripod for detection of a crime: authorship, materiality, and culpability. So in authorship, and Professor Ariel and Professor Juliano have already said something about it. So it's really hard to detect who to answer these questions. Who did it? Who asked for it? Who planned it? Who intended it? And it's not so hard to see the result, the materiality, but it's not enough to identify and to punish a violation. But it's really hard to determine culpability, even more if we are talking about AI as a tool or AI as a decision maker, right? It's almost impossible, I would say, an impossible task of pursuing a discovery and proving an offense, in this case, like a collusion or price fixing offense. So this is what you already know. As I mentioned earlier, the classification of Professor Ariel and Professor Stuck, right, on algorithms and pricing. I mean, I will summarize it because Professor Ariel has already told us so. And you must know that I'm writing a paper with Vinicius Klein, Professor Vinicius Klein, about this presentation, right? So I will go very fast on this. It will be free online afterwards if anybody who is watching this would be interested. But what is the conclusion? From tools or to robots obeying a direct order from a master, right? And if we talk about smart decision makers, it becomes hard to identify authorship or even to deal with accountability. For example, in the type 3 and 4 of Professor Ariel and Stuck. And you have also this algorithm pricing blockchain, and in two situations. Hold on, please. Okay, so here algorithm would be like used as a illegal tool. Sorry guys, homeschooling. And then you can see Professor Mikhail Gal, who has a very deep research on this. But we also have, I'm feeling like a woman now, doing many things in the same time, but I'm still a man, so it's not working well. Right, and then we have Professor Thibaut Cherpel, a friend of mine, who understands, and very recently, that blockchain could be the solution. Blockchain code is antitrust. Very, very interesting paper. I recommend to anybody who is interested in the topic. Okay. But what is the solution? What is the path? What we should do to find inside the chain the solution, or to use the chain to monitor AI behavior, to monitor the ecosystem. I found very nice the idea of the ecosystem, the control of ecosystem overcomes the market power concept, right? Maybe we have a potentialized concept of market power. Who knows? But actually, going a little further. So now, I like this one as well. Going back to the main problem, I happen to identify at least 3 ways of facing the challenge. Hold on a second. Little way, it's cooling again. Por favor. So, we have at least 3 ways to tackle this. Use AI against AI, which involves maybe empowering the agencies with special AI units and tools. We have some papers in this direction. Applying high-tech versus high-tech. Nice. This, for example, is something that we found in the paper of Cowgill-Tucker this year. I think it's a nice idea, but still not enough. We can use compliance tools, what I start to like a little more than just empowering the agencies, because as long as AI can make decisions, as Professor Ariel showed to us, and I believe it, if you live up in a algorithm inside the internet realm, and it might be likely to find that aligning prices is the best way to perform. So it will end up colluding without a direct order. It kills our legal matrix for punishment, right? So maybe compliance should be an alternative, and establishing norms or limitations in the architecture of the algorithm, but without a legal requirement. And this is, you can find it in the Antitrust by Design in Louvre and Save 2 years ago in a paper. Or we can go a little further towards another utopia and rewrite the law for AI or digital platforms. So what is rewrite the law? This is the challenge that myself and Professor Vinicius are facing now. It's not an easy challenge, I must say, but we are thinking of working on a new legal discourse, legal language that would combine the language of the algorithm, the programming language, and the language of the law, the rule of law inside the programming language. And we believe this is, of course, has many challenges, but could allow for a mutation or a mutated version of that Beccaria's idea under a compliance matrix. Therefore, we should solve the problem of authorship and culpability, anticipating the ifs and nos and the limitations of the machine itself when dealing with the information and data inside the digital realms. So that's pretty much what I have prepared for today. Thank you very much for your audience. And I will be, okay, here's the references. As I mentioned, it will be online for free. And I thank you very much, and I'm open for questions and discussions. Thank you very much.
Thank you very much, Professor Eduardo. It was very interesting, very nice to see, including the movies that we remember. I think The Matrix is one of the best movies ever. So it's interesting to see artificial intelligence and antitrust law together. We do have a lot of questions, but I think we should first listen to Professor Vinicius. I know that Professor Juliana and Professor Eduardo they both have appointments today, so thank you very much for joining us, for taking some time to debate antitrust law and digital markets. And I would like to ask Professor Vinicius Klein for the final, last but not least important, explanation about competition and digital markets. So thank you and welcome, Professor Vinicius, and thank you again, Professor Eduardo, for your thoughts.
Thank you very much, Vanessa. Thank you all. Thank you, Professor Juliana and Professor Eduardo, that made time to be in this event. And I'm very happy to organize this event with one of the major figures of competition law and digital markets. That's Professor Ariel. As Eduardo said, we are studying this topic, and we read Professor Ariel book and Professor Ariel papers, and it's very important papers and very important books. So it's very it's an honor to be here and to talk about the subject. I'm trying to share the screen, but I don't know, it's not appearing. Here, no, it's sharing. You guys are seeing the presentation?
Yes, it's working, Vinicius.
So, thank you. My idea here is to try to do a different perspective in this subject. I know that Professor Juliano talked about important subject in this discussion, that is data. I know that Professor Eduardo talked about one policy agenda or one policy approach, that is the coding antitrust, that the work we're doing together. And we had the best presentation ever was Professor Ariel, who made the framework of all the discussions. So my idea here is to do a little different topic and try to think about the role of economic theory in the challenges presented by digital competition. Because the discussion that we are having today, and Professor Juliano talked about an important point, the difficulty of using the concepts usually used and presented in antitrust to this problem. But there is a very important discussion if economic theory is going to have this important role that it has in the Chicago way of viewing things and the consumer welfare standard in the future in digital markets. And I would try to do that as a law and economics professor. I think that's a safe field for me. The idea here is to try to do and show that the relationship between law and economics is very close to the antitrust movement in the United States since the beginning, since the conception. It's not just when the second wave of Chicago Law School or the consumer welfare standard has consolidated that economic theory was there. Economic theory was there from the beginning. And it was not the Chicago School or second Chicago School of antitrust, but it was economic theory. It was the Harvard, who I know that it's a different way of viewing economics, but it was economic theory. And if you talk about in the European Union, that I think it's a very shadow subject. I discussed that with Professor Marti on our last webinar about competition law. in European Union, there is a role played by ordoliberals that sometimes we forget because we usually just mirror United States discussion and United States antitrust. But if you think about European Union, there is ordoliberal thought. The idea, like, there was the economic discussions in antitrust before the consumer welfare standard. There was barriers to entry, costs, what kind of costs you're going to take into the analysis, things like that. So the economic theory was there. But what was, and I want to be very brief because you probably are very tired of very beautiful presentations, but what was the difference between the before and after the consolidation of the consumer welfare standard? Was this claim, and Professor Ariel has a very important paper I like a lot. It's Sponge, the name of the paper, and he used that word purity. So the claim of the consumer welfare standard, it's a claim of purity. Or there is, like, Professor Crane has this uses the expression technocracy, but I think they try to say about the same things, more or less. When you have economic theory, you have legal certainty, you have objective analysis, you have confidence that economics and competition law is going to deliver a result that is not subjective. It's objective, and you can have confidence in that. I think you have to make it analyze the question in two things. First, this quality of purity or of certainty, it's from economic theory or just from Chicago school economic theory. So who gives legal certainty? It's the consumer welfare standard or economic theory in general, because it's different. You can have an economic theory approach to antitrust that's not just Chicago School of Antitrust. And this difference, I think it's important, because now antitrust is having a challenge. The consumer welfare standard is having a challenge. And this challenge, it's interesting because when the conception of the antitrust movement and the Sherman Act, the challenge was made in the economic theory. The neoclassical economic theory was not consolidated; it was emerging. So the dialogue between law and economics was between a science that had a shift in paradigms, in dominant views. Now it seems like economics is more monolithic, and antitrust is subject to more challenges, to more different views. And the people that think, as Professor Ariel presented, that big techs and the dominance of the ecosystem, all the problems of digital markets presented here, cannot be dealt well with antitrust, they usually have this argument that you cannot deal with that with antitrust, because antitrust is going to have noise, is going to lose this quality of legal certainty. But if we have public hearings now in the United States and have a lot of debate in the literature, if we're going to have this public discussion about antitrust, because antitrust was a very important movement in the public opinion some times ago, right? In the beginning of the Sherman Act, and then the antitrust movement disappeared from public opinion. Nobody in the elections, for instance, United States talked a lot about antitrust, but in this election, things are probably going to change. You're going to have a lot of proposals about antitrust and antitrust enforcement against big techs. So if the antitrust is going to be back in the public realm, in the public discourse, in the public debate, let's try to analyze this topic. The purity of antitrust is in stake when you lose the consumer welfare standard. And the integration of non-economic concerns could lead to an important lack of legal certainty and predictability of competition law that could harm not only competition, but also innovation and economic development. Is this really the case? Or this is an argument that tries to exaggerate the qualifications of the consumer welfare standard? I think that discussion is important. We have a benchmark that's important benchmark. Professor Ariel is from there, is from Europe, and can can say better than me, but usually it's common in the literature to say that European Union has more goals than United States, and some of them are not economic. It's market integration, it's the economic process, it's fairness, it's lots of, and European Union has lost its certainty and predictability in antitrust. I don't think so. But one of the challengers usually have a lot of challenge. Now we have a discussion, and lots of people are going to question one or another thing that's keystone concept of the consumer welfare standard. It's the hipster or new populism, antitrust, and it's a lot of different opinions, but there is no rejection, in my view, of the economic tools, but they use and try to include more broad and porous scope of analysis. So more discussion about some other things. I think the role of economic theory will be preserved if you try to deal with things like political influence, like Professor Juliano told us about the informational concentration as related to economic power and economic concentration. If you're going to deal with this, we can deal with that with economic tools. Yes, we can use the concept of incentives. You can use a lot of concepts like Professor Ariel has worked about that and has spoken about that, about behavioral economics and behavioral antitrust. If you're going to try to deal with corporate power and political influence, we have political public choice concepts. We have the concept of the concepts developed by Professor Luigi Zingales, that the Stigler Center was one of the slides from Professor Ariel. So we have a lot of economic theory that can be used and try to maintain a little bit of legal certainty and predictability. The question is, you have to change so much I think that is one of the questions that Professor Juliano spoke at. You have to change the concepts. You have to change concepts like market power. You have to change concepts like market share. It's a very big discussion about market share in digital markets. And is economic theory working to develop new concepts, or a concept that's different from market share that can be used in another kind of antitrust? And even if we lose some of the legal certainty at some level, at some acceptable level of legal certainty, this is not going to make the society better off. If there's a problem with digital markets, with the control of the ecosystem, as Professor Ariel told us, this can be a good idea. The net effect, that's something important in antitrust or in competition law, can be positive. And I think the rationality of the analysis could be preserved. You can have like behavioral finance, for instance, and this is, I think, important and a good parallel between high frequency trading and antitrust. If you change the efficient hypothesis market from Professor Eugene Fama for behavior finance or for microstructure approach, you continue using economic tools, and you can have some level of rationality, some level of legal certainty. Maybe you can lose a little, but to stick in the efficient market hypothesis can be a problem. If this concept is not able to deal with the different things about trading, like if the information is not the key and the velocity is, and the hypothesis is grounded on the think about information, so maybe you need to change economic theory, use it. You have some different concepts like predatory innovation. Professor Thibaut Chappelle has a paper about it. Mavericks, behavioral law economics, Professor Ariel has worked about it. Professor Maurice Stuck has worked about it. Deal different concepts. So, in my view, the departure from the consumer welfare standard is not necessarily a departure from economic theory and from the relationship between law and economics and antitrust or competition law, and not necessarily a departure from legal predicability and rationality of enforcement. When you think about digital market, is the think about the code, the blockchain things that, as we are discussing, I have working with Eduardo to try to write something about it. And the use of coding and trust or coding antitrust rules in digital markets, or use blockchain and smart contracts. It's a way, but you have a previous webinar here with Professor Felipe Martí was very good. And I think Professor Martí was watching here, so thank you very much again for the last webinar. And we discussed a paper from him that he says there is need more technique, more maybe computer science. So maybe there is another question. Are we going to replace law and economics for law and computer science, or law and technique? Or can we have the three of them? Law, economics, and computer science together. There can be a division of labor here. And I think it's possible to have this division of labor. If you think about like coding, blockchain, smart contracts as a means of enforcement, for instance, you can have this means of enforcement and use economic theory. Maybe not just the consumer welfare standard concepts, but also behavior, maybe experimental economics, maybe some new concepts, maybe new institutional economics, or come back to old institutional economics, so another kind of economic thinking. And you can try to lose not so much predictability, and also have been able to deal with different challenges, to cope with this more difficult and more new challenges. So this equalization as Chicago economic theory is equal to legal predictability and antitrust, I think it's misleading. And one of the points of my presentation is try to change that view. You can have digital markets with try to deal with different challenges with some other kind of economic theory, and also include things about computer science or coding, and not lose all the legal predictability, all the legal certainty. And you can keep this important relation between law and economics and competition law and antitrust. I think they are very linked from the beginning, and they could be linked in these new challenges that we face when we have these digital market problems. So thank you very much. Here's as a reference, a lot of Professor Ezrachi here, and thank you very much.
Thank you very much, Professor Vinicius Klein. It was wonderful to learn again from you. So we're kind of in a hurry because as professors, we like to talk a lot, especially about competition law and competition policy and online about digital markets. So we don't have enough time to answer all the questions. I would like to thank all of you who sent questions. So Pietra Quinelato, Roberto Domingues Taufik, Veronica Marques, Jackson Torres, who's here as well, our federal judge, Stephanie Willie, who is here listening to us and liking our event. So it's amazing to have you all right here. And I'd like to bring at least one question. What do you think? Can I bring one question so we can answer in like 3-4 minutes? And I'll bring Pietra's question talking about behavioral economics concepts. She likes to know about biased user decisions on platforms and their possible harmful influence in the formation of personalized prices. So what do you think about these personalized prices and this behavioral economic analysis starting from that? What do you think? Do you want to talk about this briefly? And then we need to end in like 5 minutes, okay? Thank you so much.
Okay, if no one wants to say anything, I'll say something. Let me start by saying that it was really a privilege to be part of this debate, and thank you all for the excellent presentations. It was really interesting to hear different perspectives on the subject. Very interesting and extremely thought-provoking. So thank you all. In terms of behavioral economics, where does one begin? I have to say that I need to leave in 4 minutes. So, I think that let me start with some ideas, and I apologize if that doesn't answer the question as specifically. I'm not sure if I fully understood what the focal point is. There are over 100 biases that are documented in the way that we react to communications. So when we meet, when I say me, I meet Maurice Stuckey and myself. As we developed our writing, we met with a lot of economists, we met with competition agencies. And in a way, if you're a rational business and your aim is to maximize your income, it would be irrational for you not to make use of those biases. So we have to separate the fact that we might be outraged on an ethical level, that someone is making use of that, and the fact that there is a whole science out there that at the moment is open to all, and it is for businesses to exploit, and it's legal. And unless consumer protection or other regulation, I mentioned repricing earlier, is utilized to prevent that, then this is open. Now, what is normal is sometimes hard to detect because those biases also happen on a daily basis. You know, if you come into my shop and you think that there is a sale, even if I increase the price 2 weeks earlier for this to be a sale, you're more likely to purchase something. So there are things that are almost intuitive to us. We understand that. And this is why in some jurisdictions, there will be a restriction for you to say sale 20%. You'll have to write, when was it last higher in terms of price? So it's obvious that you didn't just increase the price the evening before for you to be able to say that this is a 50% discount. And still, there are manipulations that are built into the process because this is the market. The market is far from being perfect. Part of what we need to understand is that to begin with, our economic theories are based on assumptions that have very little to do with reality, assumptions of rationality, of profit maximization, that if they were true, there would be no advertisements, there would be no loyalty, there would be nothing in the way that we operate. Now take that and filter it into the reality of digital markets and virtual competition, and you realize how further we move from those assumptions. And making some reference to the presentations, that then raises the question as to whether we need to adjust our theories of harm, whether we need to adjust what we consider to be a harm, what we consider to be power. And there are risks there, because when you do that, when you stretched, if we spoke just now about market power, if you stretch the concept of market power, you risk destabilizing the integrity of the definition. Does it mean that you shouldn't do that? Not necessarily. If what you have is de facto market power, if I locked you in and I control your outside options, maybe I do have market power regardless. If I control the ecosystem, maybe I have market power. Whether you should intervene or not, it's such a charged question. Some people will tell you that it's a very simple empirical question. Basically, if you cannot count it, then it doesn't count. That's the argument against intervention. If I have used for the past 50 years an equation and you cannot filter your problem through my equation, then there's no problem. Other people, including myself, would say the fact that you minimized antitrust and drove it into irrelevance in your jurisdiction, and I refer to, let's say, imaginary jurisdiction in this case, does not mean that whether there is a problem or not should be addressed through that prism. And this is where you have a very lively public debate that is very uncomfortable, because it requires us in a way to admit as to the limitations of the discipline that we all advocate. It requires us to admit of how flexible competition law is, and how many times we pretend as if it's like mathematics. But in reality, it is packed with policy, because even the decision to follow a very narrow narrative is a policy decision. Even the decision to say that all you focus is on efficiencies, and efficiencies are competition, is actually a policy decision driven by your desire to limit the enforcement. So digitalization brought us back many years back and required us to open this Pandora box and ask ourselves, so what is the discipline about? And once you do that, you challenge a lot of interest, you risk a lot of money. So it's no wonder that you have so much pressure groups. I'm not sure I know who's right and who's wrong, and it doesn't matter what I think. I think the interesting thing for each and everyone who listened to our discussion today is to make her mind or his mind as to what you think is right or wrong, and then ask questions accordingly from whoever are the enforcers and policymakers, and accept that some other people might disagree with you. That's part of the beauty of the debate, the vulnerability of competition law and the debate that we have on its future. I'll have to end with that. I want to thank all of you. It's been really delightful to be part of the debate. I enjoyed it very much.
Thank you so much. I'm sure we all have learned a lot from you. Again, besides everything that we read here in Brazil about your work, Professor Ezrachi. And Vinicius Klein, Mr. Patterson, Professor Juliano, I thank you all for joining us, especially Professor Ariel Ezrachi. We hope to see you here in Brazil soon. As soon as the flights come back, you'll be very welcome at our universities here. And I'm sure we all have a lot to learn from you. So thank you very much for joining us today. Thank you from everyone who's watching right now, for everyone who sent questions, and we hope to see you again on our next webinars. And it's wonderful to see you online, right? Since we cannot leave our home. So thank you very much. Have a great evening, Professor Ariel, and a great afternoon from everyone here in Brazil. So see you. Bye-bye.